Yes, sir.
Thank you.
I only have a couple more questions. Thank you, Mr. Earls. I remember being asked by the defense lawyer about a Red Bull can.
Yes, I do.
And then you testified that when you observed it, it was in the water. Is that correct?
Yes, or in the stream bed.
Or in the stream bed. I've already showed counsel what has been marked for identification of State Exhibit 441 and 442. May these be taken up to Mr. Earls for review?
Yes.
Thank you. Mr. Earls, please take a look at those two exhibits marked for identification.
Okay.
Do you recognize what's shown in State's Exhibits 441 and 442 for identification?
Yes, I do.
And what are they?
These are mid-range and close-up views of the Red Bull can that's in place within that riverbed.
Is this the same Red Bull can that you testified earlier when the defense attorney asked you about that?
I think so, yes.
And did you take those photographs?
Yes, I did.
And where did you take those photographs?
These were in that riverbed right near the scene at Nua'alua Road, off of Nua'alua Road.
Okay. Do they actually depict the area and the stream, especially, more specifically, the stream area where you saw the Red Bull can?
Yes, they do.
Have they been changed or altered in any way?
Do not appear to be so.
Your Honor, at this time the state would move into evidence State's Exhibits 441 and 442 for
Yes, sir.
identification. No objection.
State's Exhibits 441 and 442 marked for identification purposes are received and open.
Okay, first I'm going to question the publisher.
Granted.
And may Mr. Earls step down and use a pointer. Okay, Mr. Earls, I'm showing you first State's Exhibit 441, which has been admitted into evidence. Can you tell us what are we looking at here?
Okay, so this is an image, like a mid-range view of this area of the riverbed or the stream bed. You can see in the bottom part on these rocks is still wet here. And then right near the center of the image is this blue part, and that's part of the Red Bull can.
And showing you State's Exhibit 442.
So that's a closer up view of the Red Bull can before it's been touched.
And then you testified, I think, on cross-examination that you had, did you try to look for fingerprints, or sorry, latent prints on the Red Bull can?
I did, yes.
And were any noticed by you?
And none were observed, no.
Or observed? Okay. And you mentioned because it was in water, you did no further testing?
Correct.
Okay, thank you. Your Honor, I don't have any further questions for Mr. Earls.
Free cross-examination, Mr. Arpo.
Okay, relative to that fanny pack, if I'm not mistaken, when I asked you about that on cross-examination, didn't you testify that you didn't make any decision to leave it there? You basically took pictures and it was kind of left to others. Wasn't that your testimony?
Objection, Your Honor, that is not for testimony that was left to others.
Well,
I'll sustain the objection, and you may, if you wish, rephrase your question.
when I asked you in cross-examination about whose decision it was to leave that fanny pack there, isn't it accurate that when I asked you, it was somebody else's decision?
The lead investigator, yes.
But when Mr. Rivera asked you, somehow it became partly your decision, right?
Objection, it's argumentative, somehow.
The objection is sustained.
When Mr. Rivera asked you, your testimony was that you had input to that decision. Is that accurate?
Yes.
Aren't the two different?
Objection, argumentative.
The objection is sustained.
And, you know, when Mr. Rivera would ask you questions, or when I would ask you questions, and you asked to refresh your recollection on your report, were you actually refreshing your recollection, or were you just reading it?
Refreshing my recollection. It's been quite a while since this happened.
Well, let me ask you, I mean, were you just reading it, or was your recollection actually refreshed such that if you walked out of this room without that report, you'd be able to testify accurately?
Judge, just been asked and answered.
The objection is sustained.
Now, relative to the black ski mask, I think Mr. Rivera asked you whether you did any lifts or trace evidence in DNA, and I'm confused by your answer. Let me ask you, did you do any testing relative to that black ski mask?
Yes, I did.
What testing did you do?
I did a presumptive test.
Okay, and what type of presumptive test was that one?
That was a presumptive test for the presence of blood, utilizing a reagent which visualizes latent or hidden blood that you can't see with your naked eye.
So aside from the agent that you use when you can detect and observe stains, you're saying there's another presumptive test for blood where you do not observe the stain?
Yes.
But wasn't your testimony relative to other items, when I was asking you questions, that, oh, if I don't see blood, I'm not going to test it presumptively for blood?
Judge, I do object because that misstates Mr.
The
Rose's
objection
testimony.
is sustained.
Thank you.
Is there any kind of presumptive testing for DNA?
No, not that I'm aware of, no, sir.
So when Mr. Rivera asked you, was presumptive testing done on something, and was it sent for further testing in accordance with your results of the presumptive test? It's not a presumptive test for DNA, is it?
Not necessarily.
Yeah, I object because there's no foundation and assumes facts, not in evidence, whether there's one or not.
The objection is sustained.
There's no foundation as to whether it's a test for blood versus DNA? I would think that he knows the difference. And that...
You know, I think if you look at the question, you may want to consider rephrasing the question, but if you look at the question, there are a few problems with it.
Can we agree that even if you were to do a presumptive test on something and it came up negative, that something can still have DNA on it?
Judge,
Potentially.
objection, Your Honor, because that calls for speculation. No one knows that.
I think that's common sense and reason at this point.
Your Honor, then we don't need to have to test common sense or reason.
Perhaps
We don't need a specialist to testify to it.
perhaps reserved for another type of witness.
Thank you.
So I will sustain the objection.
Well, based on the questions Mr. Rivera is asking you, it sounds like if it didn't come up with a presumptive test for blood, you weren't sending it out for DNA tests. Is that accurate?
I would have to review all the items that were sent out, but generally that is the procedure. It's an indicator, it's a presumptive test.
So your testimony is that if you don't see blood, you don't do the presumptive test, right?
Judge, objection, that's not the testimony, that misstates.
Yeah, yes, the objection is sustained.
Thank you.
Well, didn't you testify earlier that if you don't observe a blood stain, you won't do the presumptive test, right?
As I said, there are two different presumptive tests.
Well, you only mentioned that second one when Mr. Rivera asked you, but when I asked you, isn't it true that you said if you don't observe blood, you don't do presumptive test?
Not that presumptive test, yes.
And if you don't do that presumptive test, does that mean to you that there's no DNA on it?
Judge, objection, that calls for speculation.
The objection is sustained.
Now, in response to Mr. Rivera's questions, you testified that both the black pair of jeans and the blue jeans, well, let me ask you, were those of the same size, waist, and length, or was that different?
They were the same.
Okay, so both of them were 32 waist, 30 inseam, is that accurate?
32x30, which typically means that, yes.
Okay. Now, when you were taking photos over at Stephen's house, did you or any other detective lift up those blue jeans to check whether those blue jeans at Stephen's house were size 32-30?
I cannot attest to anyone else, but I know I did not.
Let me ask you straight up under oath.
Judge, objection, this is argumentative,
Yeah,
the way he's
Mr.
phrasing that.
Yes, the objection is sustained. Why don't you just ask the question? You don't need the phrase.
Didn't you see one of the other officers pick up those jeans to check the sizes?
I cannot remember that at all. If I saw anyone else pick up every particular item that was inspected in the room. If I would have seen that and it was brought to my attention, I would have photographed it close up.
So it sounds like you pretty much stay... I mean, is it your testimony that you don't do any thinking at the scene, you just go to where a police officer tells you to go make photos?
Judge, objection, that's argumentative.
The objection is sustained.
So, since the defense attorney brought this up, with respect to not being able to,
Object this argument.
The objection is sustained.
with
Just
respect
ask the
to,
question.
thank you, with respect to not seeing a blood-like stain on something you consider might be of interest or evidence in the case, is there a presumptive test that you would do on that item?
Yes,
And is that the second test that you've referred to?
correct.
Now, the first test you've referred to, if you do see something that may look like a blood-like stain, is that handled differently than the second type of test?
Yes.
Okay. And what's the difference between the two tests as far as handling that? Something with a blood-like stain and something without a blood-like stain?
Getting into details of how it's conducted, or?
What is your procedure in conducting the test?
Okay. So test A, when you see a stain and you want to know if it potentially could be presumptive for blood, then you actually swab that stain that you see with a cotton swab and sterile water. You place the reagent on it, and then it gives you a certain answer.
When you say the reagent, you're talking about some kind of liquid or formula?
Yes, yes.
And then when you, the second test,
Excuse me. Yes. And when you say, when you place the reagent on it, what is it?
I'm sorry, on the cotton swab that has the sample now on it. Thank you. Sorry
Thank
about
you, Your Honor. And then the second test you've referred to, when you don't see a blood-like stain, but you want to test a certain item to see if there's blood that your naked eye is unable to detect, what is the procedure for that?
Correct. And that test is a different reagent that is actually sprayed onto the item in complete darkness and creates a result that is indicative or not.
And did you do the second test on, for example, the black skirt and the blue blouse or tank top with the white polka dots,
Yes, I did.
as well as the blanket, the green blanket?
Yes, I did.
And did you do that with the black bra as well?
Yes.
And after you did the second presumptive test, let's strike that. No further questions, Your Honor.
Mr.
No further questions.
Are there any juror questions?
Yes, sir.
Okay, we'll have you. We'll have you go to the jury room. We'll see you on Monday.
Hey, Judge, if you want to be real, I have no objection to allowing that to happen. I don't know.
Yes.
That may be,
I have no objection to excusing the jury for the day.
Or maybe that's two.
you know,
Are those all for me?
do you want to go now, or?
Yeah.
You do? Okay. Then, why don't you have a seat for a second? Okay. Okay, so what we'll do is, we're obviously going to continue, but we'll let you go for the day. And I really want to thank you so much for your service as jurors this week. You know, we've got a special schedule coming up in the next 2 weeks, so I think you're all up to speed with that. And because we have a couple of jurors who will be unavailable, and you folks let us know about that long ago, so that's not a problem. Keep in mind my cautionary instructions remain in effect, all right? So don't talk to anyone about the case. Don't allow anyone to talk to you about the case. Do not read, watch, or listen to any news accounts to discuss the case. Do not attempt to conduct any investigation on your own in any way, shape, or form with respect to the case. Do not talk to any of the lawyers, the witnesses, potential witnesses in the case. Do not conduct any type of research on your own, be it through hardbound books, softbound books, libraries, or any electronic means. And as long as I'm on the topic of electronic means, because there's so many different forms of communication, the simplest being a telephone call, and in today's world there are so many different social websites that honestly I'm not really up to speed on all of those, but because there are so many of those things and so many other electronic sources, please be on your guard with respect to any of those, because there can be so many different ways that communications can occur and can inadvertently come to your attention. So keep that in mind, and you would want, if you use computers, handheld devices, whatever the case might be, to read on the internet or any other source, I understand, but just be on your guard to make sure you don't come across anything that might have anything to do with the case or any of the individuals involved in the case. When I say involved in the case, it can be any of the potential witnesses, any of the places involved. Also, I wouldn't want you to get onto something like Google Maps and take a look at various scenes, because then you're conducting your own investigation. So those are just some examples, but in watching so this has nothing to do with the case, but in watching just what goes on in the news, or what's discussed in the news about, for example, the presidential election, seems like there's a lot of stuff that's out there on the internet and through social media sites. So obviously this example has nothing to do with the case, but it's just I think a good example of how much information gets passed along through various forms of social media. So be on your guard on that. And if you even think that something might have anything to do with this case that's on any form of social media, immediately stay away from that. All right. Just remember, the simplest way of remembering this is any decision you make in the case must be based strictly on the evidence you receive in this courtroom during the trial and the court's instructions of law. Any other source is something that we have to keep you away from. And thank you so much. You folks have been so good with all of us, and I can't thank you enough for your dedicated service. So thank you. Have a nice weekend. We'll look forward to seeing you on Monday. Maybe we'll be here for the weekend going through the questions. I'm just kidding. All right, take care now.
9 o'clock.
Yeah, 9 o'clock. All right. And Mr. Earls, you can go as well, because thank you so much.
Oh, thank you.
Have a good weekend.
Thank you.
Monday's Monday's an issue. It has to be Tuesday because they have to get the admin approval. So as soon as we can, they're going to text me to rebook that
For Tuesday.
for Tuesday. Okay. Actually, I'm going to phone.
All right, Counsel, you can be seated. No problem. All right, we'll start going through the questions. The record reflects the jury is no longer present, and the witness is no longer present. All right, as it is obvious, we have a lot of jury question forms, so we'll just start going through these. The first jury question form is one question. It reads, what are the brand name of the black jeans, parentheses 30/32, close parentheses? Mr. Rivera.
No objection.
Mr. Ockel.
No, just.
All right, this question will be asked. I notice it says 30/32, and one might say it's 32/30, but in a way it might not hurt to get that clarified as well. All right, next jury question form. First question, there look like there are at least 3 questions. You testified that decisions about evidence is decided by the lead investigator, but you also stated you had decision input with other MPD detectives whether or not to collect the fanny pack, yes or no? Mr. Rivera.
No objection.
Mr. Uppool.
No objection.
This question will be asked. Next question. DNA testing by swabbing a Coke can or face mask can be sent for DNA testing, yes or no? Mr. Uppool. Mr. Rivera,
No
sorry.
objection.
Mr. Uppool.
No objection.
All right, this question will be asked. Next question. You stated that you had to wait for Honolulu to request your evidence items for testing. Eventually, did all evidence get sent to Honolulu and was tested according, let's see. Oh, let me read that again. You stated that you had to wait for Honolulu to request your evidence items for testing. Eventually, did all evidence get sent to Honolulu and was tested accurately for DNA? Yes or no? Explain details. You know, the word accurately, I mean, that's what it looks like to me. Anyway, that's the question. Mr. Rivera.
I do object to this speculation and no foundation.
Mr. Ruffalo.
Checked on those grounds as well as vague with the reference to all the evidence.
All right, next, okay, sustained. Next jury question form, one question. Is it possible to dust for fingerprints on the river rocks? If so, did you? Mr. Rivera.
No objection.
Mr. Ruffalo.
No objection.
All right, this question will be asked. Next jury question form. First, and there look like there are two questions. First question, after swabbing the glove, could skin cells be recovered for DNA testing? Mr. Rivera.
Your Honor, the cause for speculation.
Mr. Ruffalo.
No objection.
All right, I'll allow the question. Next question. At the remote hidden area at Nu'alua Bay, where evidence was found, did all your collected evidence receive presumptive testing prior to determining whether to include it for DNA testing in Honolulu or not? Mr.
No objection.
Mr. Uppo.
Vague and confusing as to what all is.
This is all you collected evidence.
I'll allow the question. All right. Next jury question form. First question. Are items of evidentiary value sent for further testing after presumptive test results are determined? Mr. Rivera.
No objection.
Mr. Uppo.
Yeah, I guess what I would object is foundation if he's not making decisions.
But he's the one that sends it out for further testing.
I'd object as vague and confusing as well.
I'll sustain the objection. All right, next question. If items turn up, let me start again. If items turn up negative in presumptive testing, would it be accurate to say that specific item would not be sent out for further testing unless you are instructed otherwise by lead detective? Mr. Rivera.
No objection.
Mr. Upmo.
No objection.
All right, this question will be asked. Next jury question form. First question. What size and brand was the slippers you recovered? Mr. Rivera.
No objection.
Mr. Upmo.
I'll object this to vague, because I think there are 2 pairs of slippers.
Are there 2 pairs of slippers?
No, Your Honor, there's one pair of black slippers and one side of a black and blue slipper. So there's only one pair of slippers.
Well, you know, actually, when I look at the question, it says what size and brand was these slippers you recovered, so it's,
I guess, yeah, if he wants to name them all, that's.
yeah, I think it actually
No
would.
objection.
Okay.
It's not restricted really to pairs, so.
No objection.
Oh, the question. All right, next question. A ski mask was found close to the crime scene but not sent out for DNA testing, yes or no? Mr. Rivera?
Your Honor, if he knows where it was found, I have a feeling he doesn't, so I mean, actually, that's for speculation.
Lack of foundation.
All right, sustained. Next question. How close was the Coke can to the crime scene? Was it swabbed and sent out to Honolulu for DNA analysis? Mr. Rivera?
No objection.
Mr. Echo?
Just object this to compound.
I'll allow the question. All right, next jury question form. First question, where is the black ski mask now? Mr. Rivera?
No objection.
Mr. Upwell?
No objection.
All right, this question will be asked. Next question, do you feel that the MPD helped or hindered your collection of evidence? Mr. Rivera?
Objection because it's improper opinion.
Mr. Upwell?
Relevance.
Sustained. All right, next question. Have you ever seen a ski mask on Maui before this case? If so, when? Mr. Rivera.
Relevance.
Mr. Upwell.
No objection.
I'll sustain the objection. Next jury question form. First question: as a evidence tech, why would you collect some of the evidence and neglect other evidence? Mr. Rivera.
No objection.
Mr. Upwell.
Speculative.
No, what I do want to object to the word neglect, that's argumentative.
All right. Well, I'll sustain the objections made by the parties. Next question: did you recommend any other items tested that were? It says where, but I believe we mean where. Anyway, it says that were not. Mr. Rivera.
No objection.
Mr. Upwell.
No objection.
All right, this question will be asked. All right, next question.
I guess, Your Honor, I should object this to hearsay.
Recommended items to be tested that were not.
Disturbed.
I'll allow the question. All right, next question. Do you feel that all the evidence that needed to be tested was tested? Mr. Rivera.
I object on relevance and speculation.
Mr. Upwell.
Those grounds and improper opinion.
All right, sustained. Next jury question form. You made the comment try to figure out
Upon.
what just messed up.
Yeah. Yeah, it's a P. A P.
Read it, see, like I said, voice,
Maybe you
read
read
it.
more. Make a comment. When.
Yeah, but that's what you see.
Yeah.
That's what I thought. Okay.
Maybe it's right upon.
All right, the question reads, you made the comment read upon when several of you decided to not do anything further with the fanny pack that was photographed at the crime scene. What does read upon mean to you, and are you stating that the fanny pack would not be related to this case although it was at the scene? Mr. Rivera.
Objection calls for speculation, and it's confusing.
Mr. Upco.
No, Judge.
I'll sustain the objection. All right, next question. Are you directed by the lead investigator as to what is truly evidence and what does not get further processed, Mr. Rivera?
No objection.
Mr. Upco.
No, Judge.
All right, this question will be asked. Next question. Mr. Earls, is it safe to say that your attention for detail is greater than that of Detective Wendell Liu when you are in the field or lab doing recovery work? Excuse me. So, I mean, and all right. So the way it reads is, I better put in the question marks. It says, Mr. Earls, is it safe to say that your attention for detail is greater than that of Detective Wendell Liu, question mark, when you are in the field or lab doing recovery work? Mr. Rivera.
Although it may be true, it does call for speculation.
Mr. Upco.
That's a lack of foundation and relevance.
All right, sustained. Next question. Please clarify, this is a next jury question form, by the way. So the first question reads, please clarify, you recovered a small body piercing
Buried in the soil. I just spelled buried wrong. Like buried in the soil.
Oh, okay.
Yeah, I spelled it
Got
wrong.
it, okay. All right, it's just the way the word was spelled. I pick up on the context now. All right, the question reads, please clarify, you recovered a small body piercing buried in the soil for evidence, but you did not recover the soiled covered fanny pack with zipper showing. You only took a photo of the fanny pack? Question mark. Mr.
You know, it's argumentative, it assumes facts, not an evidence, whether the body jewelry was covered.
Mr. Upco.
No, Judge.
I'll allow the question. All right, next question. Were you instructed not to recover the fanny pack, just take a photo of it? Mr. Rivera.
No objection.
Mr. Upco.
No, Judge.
This question will be asked. Next question. In your line of work and knowledge, based on your master's in forensics, your training and experience, if you air dried the ski mask and swab the mask, mouth, nose, and eye areas, DNA evidence would be recovered for testing, yes or no? Mr. Rivera?
Cause for speculation.
Mr. Upon?
No objection.
All right, I'll sustain the objection. Next. Next jury question form, first question. Is it standard procedure not to manipulate or rearrange evidentiary items versus professional work ethics not to contaminate any evidence? Mr. Rivera.
Your Honor, that's, the question is vague and confusing.
Mr. Upon.
I need to admit it, but on that note, may I have the question reread, Your Honor?
Sure. Is it standard procedure not to manipulate or rearrange evidentiary items versus professional work ethics not to contaminate any evidence? Mr. Upon.
I'd object this to vague and confusing.
All right, sustained. Next question. Were both vehicles observed on February 27, 2014, or which one was observed? Toyota 4Runner, Ford Ranger truck. Mr. Rivera.
No objection.
Mr. Upwell.
No objection.
All right, this question will be asked. Next question. Who and when you were instructed to cut down the tree at Paraquats Bay? Mr. Rivera.
No objection.
Mr. Upwell.
No objection.
All right, this question will be asked. Next jury question form, first question. In your line of work, whose decision is it to randomly collect, process, and send out evidence on some items but not on other items that are all collected from a crime scene? Mr. Rivera.
Objection is argumentative, using the word random.
Mr. Upwell.
I have no objection, and on, you know, in terms of the state's objection, if the juror interprets it as random, it shouldn't preclude the question.
I'll allow the question. Anyway, all right, next question. Is there documentation in your records, gene sizes of the bloody one pair found on the side of the Hana Highway, size of the pair at it looks like it's misspelled, but anyway, New Wailuku Bay, but it seems to be misspelled. And the size of pants, the defendant, and all other persons of interest. Mr. Rivera.
Your Honor, that's compound.
Mr. Upwell.
Compound and lack of foundation.
All right, sustained. Next question. How many tree limbs did you handle, process as evidence, do presumptive testing on for this case? Mr. Rivera.
No objection.
Mr. Upwell.
No objection.
All right, this question will be asked. Next jury question form, one question. Was any evidence testing in this case restricted by budget constraints? Mr. Rivera.
Cause for speculation.
Mr. Upwell.
No objection.
I'll sustain the objection. All right, next jury question form, first question. If some items were presumptive tested and other items were not, and some items swabbed for DNA but others were not, would you agree that this could exclude all evidence possibilities based on your education, training, and experience? Yes or no? Mr. Rivera.
Your Honor, the answer would call for speculation.
Mr. Upwell.
No objection.
It's also confusing as to the way it's worded.
I'll allow the question. Next question, can you explain in detail what kind of testing for evidence was done on the Forerunner doors recovered? Mr. Rivera.
You know, to the extent it goes into the direct testing itself, it may violate the court's instructions as to what can be asked about the presumptive testing.
No objection.
All right, I'll allow the question. Next question, was there a problem with the swabs collected from the slippers as to why the DNA swabs were not sent? Mr. Rivera?
No objection.
Mr. Oppo?
No objection.
All right, this question will be asked. Next jury question form. All the times you went out to Nu'ailua Bay, and again, it appears to be misspelled, but at any rate, all the times you went out to Nu'ailua Bay crime scene and evidence was collected, was the crime scene secured, or could public get my law clerk and writing expert here. Let's read the question.
Public searchers access the area. Searchers, I think. SEARCHERS.
Okay, gotcha. That makes sense. You can sit here if you want. All right,
Ask your questions.
okay. Question reads, all the times you went out to Nu'ailua Bay crime scene and evidence was collected, was the crime scene secured, or could public searchers access area? For example, you collected items on February 14, February 15, February 24th, 2014. Mr. Rivera.
For that specific question, no objection.
Mr. Apple.
No objection.
All right, this question will be asked. Next question. After items are dried, are you able to attain DNA from the item? Mr. Rivera.
You know, that calls for speculation and lack of foundation.
Mr. Apple.
I guess if we're interpreting the question as if he can actually obtain it, I guess I join Mr. Rivera's request. If we're interpreting it as if he can try to obtain something, no objection.
Okay, I'm going to sustain the objection. All right. Next question. After the fanny pack, green tank top, face mask, cell phone, and hiking shoes were dried, was DNA swabbed off these items? Mr. Rivera.
Yeah, I believe that in the state's testimony,
Mr. Oppo.
No objection.
And when you say misstates, you're referring to what?
the hiking shoes.
Mm. I'll allow the question. I think the witness can clarify. All right, next jury question form. Why are some items of evidence important? For example, fingernails, body piercing, hair clumps, and clothing, but other items not so much. Example, ski mask, fanny pack, cell phone, soda can. Mr. Rivera.
And the cause for speculation on Mr. Earl's part.
Mr. Oppo.
No objection.
All right, I'll sustain the objection. Next question, why did you not DNA swab all items of evidence collected? Mr. Rivera.
No objection.
Mr. Oppo.
No objection.
All right, this question will be asked. Next jury question form. First question, was the cell phone found identified? What type of phone was it? Who was the cell carrier? Mr. Rivera.
And the cause for speculation.
Mr. Oppo.
No objection. He's already answered two of those, the last two of those, I know.
Yeah, I guess, I mean, if it's not hearsay, it'd be okay, but I'm not sure. Do you folks know?
Pardon me,
Did he check on all these?
no, he
Okay.
does
No,
not.
wait. He testified relative to the brand of the phone,
Yeah, you asked him
as
about
well
that.
as that. So there was the LG and Verizon. But what was the first one?
It says,
Yes?
was the cell phone found identified? What type of phone was it? Who was the cell carrier?
Yeah, so I'd have no objection in as much as it's already been asked and answered in substance.
Well, when it says was the cell phone identified, that could mean several
Yeah,
things.
that's-
in
I'm
my
reading
mind.
it as in terms of identified, in terms of the brand and the carrier.
Yeah, well, the next question is what type of phone was it? So I'm imagining the first question as asking for something else.
My position relative to that question will be I'll defer to the court.
I mean, if he,
He didn't do any follow-up on the phone. It's not.
okay, well, then,
it's not important.
because I think the two questions he could answer have been answered, so I'll, you're objecting to the question?
Well, it's asked and answered for that part, but for it to be identified, that calls for speculation on his part.
Yeah, I'll sustain the objection. All right, next question, was the cell phone found sent to the FBI, Michael Easter, for evaluation, Mr. Rivera?
Your Honor, that would be, assumes facts, not an evidence. Michael Easter's not, he doesn't get cell phones, and he's testified to that. He's not a forensic cell phone.
No objection.
I'm going to agree with your statement that Michael Easter's not a forensic cell phone.
Forensic cell phone expert.
Oh, the thing is, John, is the juror.
I'm just kidding.
I left the word out.
This is, apparently the juror interpreted his testimony to,
Yeah, I'll allow the question. I mean, it's a question he can answer because he's the one sending out the evidence, so. All right, next question. When you left the crime scene on the 14th and returned on the 15th, was the scene secured by MPD so no searchers or public could enter, Mr. Rivera?
It calls for speculation.
I think I asked and he answered and there was a lack of foundation, but
In this particular instance, the question is fairly specific in terms of time.
yeah, I'm not
It
going to
says when you left.
Right, I'm going to take no objection on this
Yeah,
question.
because that's the way, because they're not asking, it's when he left, was it, secured? He can testify to that. I don't think he can testify about whether it remained secure through the night, but the question starts with when you left the crime scene. Was it on the 14th and returned on the 15th? Was this? So those 2 points of time, when he came back on the 15th and when he left on the 14th, was it secured?
As long as it doesn't imply that it was secured while he wasn't there. Because like the court.
Well, that's why I'm saying that the question begins when you left and then, when he returned. Those are two specific points in time.
If you take it that way, but it doesn't sound that specific.
You know, this question may very well be asking for, through the night. I get that, but the way it's worded, it would seem to be. You have any objection, Mr. Upwell?
No, I don't have.
I'll allow the question, and then you folks can clarify and or object if you deem it appropriate. All right. Next jury question form. First question: show exhibit of tree, please. And then it reads: could the photo of the tree be enlarged to view the tree behind the tree that was cut and brought in? Is there a cut in the tree behind the cut down tree, Mr. Rivera?
No objection.
Mr. Upwell?
You have scope?
All right. No, actually, there were a number of questions about other trees being cut, Mr. Upwell. So I'll allow the question. So we'll need to make sure you queue up the appropriate.
There are a couple of photographs.
And then we'll need, we have the tree, so, okay. All right, next one. Please clarify, you collected a maggot-infested black bra with cuts, but did not collect a muddy fanny pack close by? Question mark. Mr. Rivera.
That's not a question, it's a statement, so I have
Mr. Upwell.
No objection.
All right, I'll allow the question. Next question. Regarding the cell phone collected, was this investigated and processed as evidence, possibly being that of Charlie Scott or related to an individual who participated in her missing? Mr. Rivera.
no objection to the first part about belonging to Charlie Scott, but I object to speculation with the second part of the question.
Sounds like the whole thing's speculative based on his testimony that decisions are made by others.
Yeah, presumably, if it was investigated by someone else. Is that a fair assumption? Or? Okay, so that would be. I'll sustain the objection. Next jury question form. First question: were the other branches and stumps that were observed with cuts were significantly and distinctly contrasting to state's exhibit of the exhibit that was displayed in court? That's the question.
No objection.
Vague, confusing, lack of foundation calls for an opinion.
I'll allow the question. All right, next question. Did you observe any evidence of pig traffic or hunting in the area where evidentiary items were found? Mr. Rivera.
No objection.
Mr. Upwell.
He testified that he's not a pig hunter for lack of foundation.
Sustained. Next jury question form. Who is your direct supervisor? This is the first question. Mr. Rivera.
Relevance.
Mr. Upwell.
No objection.
All right, I'll allow the question. Next question. Was there any blood found at your yellow tinted area, Mr. Rivera?
No objection.
Mr. Upwell.
Lack of foundation.
All right, sustained. Next question. Does MPD have control over all your evidence you work with? Mr. Rivera.
Vacant, confusing, source control.
Mr. Upwell.
No objection.
All right, this question will be allowed. Next question, jury question form that is. On all the items collected at Wailuku Bay and again, no Wailu is misspelled, but at any rate, on all the items collected at No Wailu Bay, was presumptive testing done on all items to check for blood or specks of blood? Mr. Rivera.
No objection.
Mr. Upple.
No objection.
All right, this question will be asked. Next question. Could blood have been on the green tank top in combination with the soil appearance? Mr. Rivera.
Yeah, that calls for speculation.
Mr. Upple.
No objection.
All right, I'll sustain the objection. Next question. Whose decision was it to include some evidence but not include other items of evidentiary value? Mr. Rivera.
No objection.
Mr. Upple.
So I'm sorry, Your Honor. Relative to the last question, wouldn't his training and experience be able to allow him to answer the question in terms of whether blood can be present even though it may be masked by mud? That there could be multiple sources of that stain?
The one thing is we don't have a foundation for that. It may be that a foundation could have been developed, but I don't think we have one developed.
So I apologize. What was this last question?
Whose decision was it to include some evidence but not include other items of evidentiary value?
Asked and answered. And based on hearsay.
I'll join that then.
I'm sorry?
I'll join that.
All right. Okay, I'll sustain. Next year question form. We still got quite a few to go through. We may want to start early on Monday just with jury questions before we have the jury come back in, because we've gone through a lot, but we've got a lot to go. But let me do this one, and then we'll stop. Next jury question form. First question. Please clarify. You collected for evidence a small body piercing and black bra, but you did not collect a black fanny pack to include as evidence for this case. Mr. Rivera.
You know, again, that's a statement, not a question.
Mr. Upple. I think we have a question almost.
I thought I just
Yeah.
heard that question.
Yeah. Ask and
I'll
answer.
defer to the court.
All right. I think because we have another question on it already, so
That's fine.
I'll not present this one. Next question. Whose decision was it to collect some items for evidence and not include other items for a case this important for all parties involved? Mr. Rivera.
You know, it's the same question as number 43, or the 43rd question.
Mr. Upple.
No objection.
All right. I'll sustain the objection. Next question. To clarify, please. Items were scattered all over No Wailu Bay, but some items were considered more pertinent than others for evidence? Question mark. Mr. Rivera.
It misstates facts. The items are not scattered all over Wailuku Bay.
Mr. Upple.
In as much as it's somewhat repetitive, I'll defer to the court.
All right, I'll sustain the objection. Okay, Mr. Capobianco needs to go back. So we'll continue. We've got at least as many and maybe a little bit more to go through.
45? Well, change it 3 at 8:15, and then,
A copy.
yeah, and then a couple other, minute fee and non-issue.
Let's see number 2. Let's just see, because sometimes these things don't come up.
Yeah.
I'll have Council and Mr. Capobianco come at 8:30 a.m. I think our calendar is going to reflect 9, but if you could, because we've got quite a few questions to go
And,
through.
you know, just for the course information and for council, we can't bring the science staff from the crime lab on Monday because they have a rule that they need 40 hours notice, so they're going to be coming on Tuesday.
Okay.
May I ask on that, what we can anticipate for Monday?
The other officers I mentioned to you, Dennis Lee.
What kind of test that's told us to be on vacation?
Okay, I'm not sure what, because we're still on record, so I'm
Oh,
not
I'm
sure.
sorry.
You both had a discussion with yourselves, and I'm not
No,
sure.
no, we're just discussing the anticipated witnesses for Monday. We'll work it out over the weekend.
All right, okay. All right, then we'll see you all at 8:30. We do have a handful of other things on the calendar, but as soon as we finish those, we're going to go into finishing up the questions. All right, thank you, and have a good weekend.
John, can you two must have that table back, please? Thank you, appreciate that. Could you just He-Man that over there, please?
Who's that?
Just He-Man that over there.